I'm Lavana from Lexus and Company, working as an intern. Today I'll be talking about decree and different types of decree. Now, what is a decree? A decree is defined under Section 2, Clause 2 of CPC 1908. A decree always follows a judgment and is based upon the judgment itself. It is further divided into 5 types. A decree may be final or preliminary. It is a formal declaration or adjudication and is conclusive in their nature. A decree is basically of 3 kinds, which can be preliminary, final, or partly preliminary and partly final. A decree may be delivered with an order itself. Now, what is a deemed decree? A decree shall be called a deemed decree, which includes the rejection of a plaint or any question within Section 144 of CPC 1908, but it does not include any sentence or adjudication from which it appears that an appeal lies as the appeal from an order. Now, coming on to the kinds of decree. According to Section Clause 2, there are 3 kinds of decrees. First is preliminary decree. In general sense, as the word preliminary states, it is the preparation for the main matter, the initial, introductory or preparatory. A preliminary decree is a decree where further proceedings have to take place before the suit can be completed or disposed of. A preliminary decree is passed in those cases when the proceedings are to be carried out in 2 different stages. The first stage is when the rights of the parties are adjudicated, and the second stage is when those rights are implemented or executed. Now, final decree. Final means the last, ultimate or conclusive or decisive in nature. A final decree is a decree which can completely dispose of the suit and settles the question in law and in fact. Now, partly preliminary and partly final. A decree is said to be partly preliminary and partly final when the court decides 2 questions by the same decree. For instance, if the court passes a decree in the favor of one party along with the direction of inquiry for the other party, the former party of the decree is final while the latter is preliminary decree for which further proceedings have to take place. The necessity of a decree. According to the CPC, it requires the passing of a decree in all suits. It is based upon the judgment and also follows the judgment, which is why it is indispensable and an essential requisite. Now, what are the contents of the decree? It includes the suit's number, the names and descriptions of and registered addresses of the parties, the particulars of the parties, the claims taken and the defenses given, the relief or remedy granted to the aggrieved party, the total amount of which the cost is incurred by whom, out of what property, in what portion,